case, from which you're about to see some further edited highlights, is just as fictitious as before, and the procedure no more legally accurate. The characters are still being played by actors, and the jury is made up of people who, at the end of the hearing, will retire to the jury room in order to be told what verdict to come to. We're now entering the 73rd day in the case of Cosmic Planning Consultants versus the Rosenberg Research Foundation, in which, by an oversight, an old people's home 3,000 feet up in the Cairngorms has been provided with lavatories situated at the foot of a sheer precipice several thousand feet below. It's been an exceptionally protracted hearing, during which both sides have put up what the judge has referred to as a veritable smokescreen of red herrings. It's in the nature of red herrings, however, that sooner or later they come home to roost, and in these final stages of the hearing we may expect to hear the flapping of their wings. Defence counsel is questioning a vital witness.
Why is he dressed in this peculiar manner?
He is a Sherpa, my lad, Himalayan mountain guide, whose occupation it is to lead climbers to the summits of such mountains as Everest.
Everest?
Yes, my lad.
What is there about the summit of Everest that makes it so vital to arrive there?
It is done in order to keep such people as Sherpa Solo Kombu here in business, my lad, and so prevent their becoming a burden on the state by reason of unemployment.
I see. And you have come here straight from the Himalayas?
Yes, sir.
Having had no time to change?
I was in the middle, sir, of taking a party up the foot of Everest when I was summoned to be here to give evidence to the court.
Where is this party now?
They're on the mountainside playing Ludo, my lad, awaiting his return.
Are they safe?
Oh, yes, sir. They're all roped together. I said I wouldn't be long.
He came here hot foot, my lad.
Hot foot?
Yes, my lad.
How hot?
Not very now, sir.
He arrived some moments ago, my lad, and has been cooling his heels.
Do you want time to cool the rest of your feet?
No, thank you, sir. I'm fine.
In view of the people waiting on the mountain for his return, my lad, it might be better to expedite matters in respect of this witness.
As long as his feet are hot, though they may be, still in certain parts, not doing any damage to the floor of the witness box.
There are scorch marks from a previous witness in another case, my lord, but no further damage.
Very well.
Counsel can now begin questioning the witness as to his dealings with Cosmic Planning Consultants.
Ineptitude is a word which has been bandied about with some frequency in respect of operations advised upon by Cosmic Planning Consultants, and in far-flung places.
Oh, certainly so in the Himalayas.
Now, when you were called upon to act as guide to such of these old folk as needed to make the descent in the small hours, were you surprised in any way to learn that it was necessary for them to negotiate so difficult a route in order to be able to attend to a simple call of nature?
Not when I knew who the planning consultants had been.
Would it be true to say that they were a byword for incompetence wherever you went?
Absolutely.
They were indeed, not to put too fine a point on it, a standing joke in places as far apart as Worthing and Walla Walla, than which no two places could be farther apart.
Oh, difficult.
Unless one perhaps were to take a very circuitous route.
Exactly.
Now, during the course of your duties, in and around Bellamy's Folly, here at the summit of this escarpment in the Cairngorms, you must frequently have heard remarks passed by the pensioners in which the sighting of the lavatories was the subject.
It was the sole topic of conversation.
Nor was the tenor of these remarks notably flattering to Cosmic Planning Consultants, under whose aegis they had been placed there so awkwardly.
They thought it was a disgrace.
In a sense, therefore, it would be true to say that this particular boob, if that is not too strong a word, was, in a manner of speaking, a vindication of an already widespread and long-standing reputation for errors of a startling magnitude.
That would be so.
Thank you.
This is a strong witness whose evidence is potentially very damaging to the plaintiffs, whose counsel must now seek to undermine his credibility in the eyes of the jury.
As an experienced mountain guide, who has been on many an expedition to Everest, among other mountains, you were called in on this scheme at an early stage to reconnoitre in the Alps for a suitable site prior to Bellamy's Folly being, as it were, found to be tailor-made for the purpose.
That is so.
And you were combing the Alps on this errand, and were at the top of the Matterhorn when news reached you that the site had been found near a home in the Cairngorms.
Yes.
What was your reaction to the news, as best you recall?
I was a bit put out.
You were, I suggest, hardly chuffed.
No.
You used the word typical, in fact.
I may have said something of the kind.
I suggest your disenchantment with this eventuality coloured your attitude and your thinking not a little.
Not really.
There was a further cause for dudgeon as well, was there not, when you returned for a time to your more familiar haunts in the Himalayas, where you were wont to stray when not on duty, in the search, perhaps, for the perfect Himalaya, the Himalaya of your dreams, the Himalaya which nevertheless perpetually eluded you.
I can't remember any dudgeon.
Well, let me remind you. It is a fact, is it not, that while you were traipsing round the Alps on behalf of the defendant, you picked up the habit of yodeling from such Swiss Alpine guides as you were thrown amongst from time to time, insofar that it began to grow on you and you found yourself doing it almost by force of habit, unaware that you were doing so.
I indulge in the odd yodel.
Rather more, I would suggest, than the odd yodel. So much so that there were complaints, and you had more than one brush with the Nepalese government about it.
We communicated.
What was the substance of those communications?
I can't remember.
Let me refresh your memory once again. The burden of the complaints made to you was that by your yodeling, you were keeping the entire sub-Indian continent awake at night, since you by now had taken to nocturnal yodeling, and that it was a case, not to put too fine a point on it, a belt up or else.
It was trumped up. I yodeled in an undertone at night.
Can you give his lordship and the jury an example of what you mean by yodeling in an undertone? Perhaps not a welcome sound to the ears of the sleeping populace around.
It echoed.
Precisely. From Himalaya to Himalaya, and thence south to Cawnpore, and even more remote regions. If the wind were in the right direction, you could have been heard as far away as Tibet.
Only once.
I would suggest to you that reactions to your yodeling were characterized by a singular lack of restraint, and that arising out of this, hackles rose on both sides.
Not all that much.
And it is this feeling of suppressed rancour that colours your interpretation of the remarks you say you overheard from the old age pensioners when descending to the lavatories at night and at other times.
I'm only saying what I heard.
Some cheerfully disrespectful remarks. Remarks indicative of a certain degree, perhaps, of blunt humour, from which there was a total absence of any kind of rancour, and partaking of the nature of light-hearted pleasantries, not to be taken too seriously.
The air was blue.
At such an altitude, in so rarefied an atmosphere, conversation might well have begun to flag, but for some such fodder to keep it going, might it not? And the pensioners might well have been grateful for some topic of this nature, to keep boredom at bay.
That was not my impression.
Nevertheless, it's possible.
It's possible, yes.
Thank you.
That is my case, my lord.
The hearing is now entering its final stages as counsel for plaintiffs embarks on his speech to the jury.
This case, members of the jury, has been marked by a number of irrelevant side issues which I propose to deal with and dispose of at the outset. We've heard evidence, for example, from expert witnesses in respect of rubber teeth. Rubber teeth, it has been said, have the advantage that if they happen to fall out, they bounce. Now, it is not perhaps generally known, for instance, that a tiger in the wild can be driven clean out of its mind by the simple stratagem of replacing its own teeth, under a suitable anaesthetic, with rubber ones. When next it attempts ineffectually to tear at its prey, the hapless tiger, unaware that rubber teeth have been substituted for its own, will look around in total bafflement as it tries ineffectually again and again to dismember its prey. What of the prey thus spared? Will it not perhaps start as a result to adopt a perhaps fatally la-di-da attitude under the erroneous impression that it bears a charmed life?
It is clearly part of counsel's strategy here, as it has been throughout, to deflect attention away from those matters which are germane to the case and concentrate instead on side issues of doubtful relevance. And this is what is happening here.
The jungle is a cruel place. And we will be wrong to suppose that this in any way justifies the contention on behalf of the defendants of this action, the Rosenberg Research Foundation, that their remarks were in any sense fair comment.
Rubber teeth having been effectively disposed of, counsel winds up his speech to the jury by referring to a point he himself raised earlier in the hearing and wishes now to heap scorn upon.
Much has been made during this hearing of the responsibility devolving upon Sir Isaac Newton in having discovered the force of gravity in, we are told, the back of a boot and shoe cupboard. Now, had he not done so, we are invited to assume, no harm would have befallen any of the unfortunate the old age pensioners whose precipitate arrival at the bottom of a 3,000-foot drop has so incommoded them. No, this is not a matter that I propose to spend time on now. Sir Isaac Newton's was a mind, in the poet Wordsworth's celebrated phrase, forever voyaging through strange seas of thought alone. Now it is there, I would suggest, that it might be left.
There, I think we might also leave it. We will resume at 2:15.
As we return to the court, counsel for the defence is making his final submission to the jury, and we pick him up as he enters upon his peroration.
It has been said, members of the jury, that to err is human. I would suggest to you that to err no fewer than 231 times, and on a quite disproportionate scale, as cosmic planning consultants have done over the years, is not human, but superhuman. The plaintiffs are bringing this case because they say they have been injured in their reputation by the words complained of. One might well ask, what reputation? A reputation for making monumental boobs? Cock-ups on a scale altogether unprecedented in the field of engineering? I would suggest to you that their reputation, so far from being in any way injured, has been abundantly vindicated. We have heard how venture after venture on which the plaintiffs have been advisers has come to a disastrous end. We have heard, indeed, of no single project which has succeeded. The record is one of disaster following upon disaster. They have, it might be said, a reputation for ineptitude unmatched anywhere in their field. All my clients have done in publishing the words complained of is to advance that reputation, not diminish it. In my submission, therefore, the plaintiff has failed to establish his case, and I would ask for judgment for the defendants with costs.
It is clear that this line of reasoning has impressed the jury and is causing some concern to the plaintiffs, who must now be anxiously awaiting the judge's summing up.
Libel is the publication of a false and derogatory statement about someone which may have a tendency to injure him in his office, profession, or trade. The defence is one of justification and fair comment. Now, in order that this defence may stand, you, the jury, must be satisfied that the words in question are based on facts truly stated, or that they are honestly believed to be true, and that the defendants were not inspired by malice towards the plaintiffs, and finally, that they are on a matter of public interest. What?
There's some problem with it.
Where?
Outside the court, my lord.
Well, is there someone there to deal with it?
It can be arranged.
Very well, very well.
Thank you.
Why does it always happen when I'm on? Oh, where's the... Oh. You are a lecturer in anthropology at the University of Wakefield.
Yes, I am.
It says here you've had wide experience in this field.
I've had wide experience in a number of fields.
How wide were these experiences?
They varied in width.
How wide was the widest of them?
Well,
was it rather wide? Very wide? Wider at one end than the other?
it bulged out in the middle.
You are not a stranger, perhaps, to experiences which bulge out in the middle.
This is a witness who, having arrived too late to give evidence to counsel from the witness box as she had hoped, must make do with a cleaning lady, in whose capable hands she can safely be left, as we go back into court, where the judge is now dealing with the evidence given by Mrs. Startferret concerning her husband's visit to a commissioner for oaths.
This is a matter which, because it has no bearing whatsoever on the case before you, you must expunge totally from your minds. For this reason, I must take you through Mrs. Startferret's evidence in some detail, since no smallest scintilla of doubt or uncertainty must exist in your minds as to what it is you are disregarding. Mrs. Startferret's husband, you will recall, was nailing up a picture of the infant Jesus in their living room when he struck his thumb with a hammer, the very hammer with which he was proposing to knock in the nail to hold the picture. His natural impulse was to cry out, using one of a vast number of putative expletives, of which it may be sod and blast would be a fairly representative example. Mr. Startferret, being a responsible citizen, restrained himself at that juncture, holding back the oath with the help of a gag quickly improvised by his spouse the moment he saw how matters lay, and made off, accompanied by Mrs. Startferret, hotfoot to his nearest commissioner for oaths, in order to let him, as the expression is, have a right mouthful, and so get it well and truly out of his system. It was no part of his plan, however, on setting out for the solicitors in the High Street, that he should be hit on the head with a chair leg almost immediately on entering. Nevertheless, this is what happened. For what followed, I must call on counsel to refresh my memory, and the jury will therefore absent themselves for a few moments until asked to return.
It is a most unusual departure from normal judicial practice for a judge to interrupt his summing up in this way. One can only assume that a page of his notes has been made illegible in some way, perhaps by Coco having been upset over them.
Nothing legible in my notes here as to how it was proposed to bring the husband round again after he'd been laid low by means of the chair leg.
But I think it was intended to give him what was described by witnesses as a kick up the backside, my lad.
Well, that would certainly be in keeping, but the whole thing seems to me to smack of the Middle Ages.
It is a bone of contention as to how best to deal with this situation, my lad. It has been known indeed for a solicitor to require help and to find himself tossing a semi-comatose client around like a rag doll in a somewhat desperate and indeed vain attempt to produce results.
Yes, a client over whom it would be a perfectly simple matter, I would have thought, to throw a bucket of water and achieve the same result much more simply.
There is a school of thought which does favour this, my lord, but it has all too frequently been known for a client to come round and kick one rather forcibly on the shins.
Yes, with the added problem that the solicitor, when so kicked, may involuntarily come out with an unpremeditated oath.
And in so doing bring the law into disrepute.
Yeah.
Instances have occurred of solicitors ending up in Dartmoor breaking stones as a result of unauthorised irregularities in the oaths procedure. And this is not an eventuality that one would wish to encourage.
Indeed not.
For many, there would be a tendency, my lord, on seeing this happen to others, to say, this is not what I came into soliciting for.
Yes, one can readily imagine some such response. It is nevertheless a matter that should be looked into with the least possible delay, possibly by the setting up of a royal commission or some other machinery such as our legislators in their wisdom may devise. I think we can have the jury back now, if you please.
Meanwhile, witness is still being questioned in the corridor outside the courtroom.
Perhaps you would care to look closely at this photograph. It is a photograph of a field, is it not, taken from the air?
Yes, I recognise it.
It is the very field, is it not, in which you had the experience, one of many, which, as you put it, bulged out in the middle.
I remember it, because normally I tend to go for the kind of experience which is the same width all the way down.
And up?
Up too.
What was it about this particular field that caused the experience you had in it to differ so radically from those you'd had elsewhere?
There were thistles.
As we go back once more to the court, the judge has come to the very crux of the matter the jury will shortly have to consider.
What you have to decide, members of the jury, is whether the words used are capable of having a damaging interpretation in the minds of reasonable people reading them or listening to them. Now let me repeat these words to you. They have made a right old bollocks up from start to finish, and we're going to take them to the cleaners over this and call their bluff once and for all. Now, you or I, reading these words in a weekly publication or a daily newspaper, or coming across them in a letter over the breakfast table, might well be disposed to think first sight that criticism of some kind is being levelled at the person or persons towards whom they are being directed. A right old bollocks up from start to finish. But let us look at this in the context of the other remarks of which it forms part. We are going to take them to the cleaners. We are going to call their bluff once and for all. Well, these are the kind of phrases that one would use, are they not, were one in a certain particular kind of mood. If perhaps one's wife had been more than usually cantankerous at breakfast, or the car battery was flat when one was attempting to start the car in pursuit of some perhaps rather attractive young woman disappearing rapidly into the distance, one would be looking, would one not, for some way of relieving one's feelings. Nevertheless, what you have to decide, having respect both to the facts and to what you know of human nature, is whether any reasonable person reading those words, they have made a right old bollocks up from start to finish, and reading them in the context of the other remarks, would modify them in his own mind in the light of what, reading between the lines, he can infer about the writer's state of mind at the time of writing them. If he says to himself, this person, this geezer, has clearly got out of bed the wrong side on the morning he wrote this, and is just getting it out of his system at the expense of the plaintiffs, so it hasn't got to be taken too seriously, then you may feel that the charge of malice falls down, since no reasonable person would attribute malice to it. If you accept this, it would seem to follow that any damaging imputation contained in the words, they have made a right old bollocks up from start to finish, is non-existent, since no reasonable person, knowing the state of mind in which the words were set down, would believe them to be literally true. The fact, therefore, that they are literally true, if, as the defendants have tried to show it is a fact, is, you may think, neither here nor there, and may be ignored, except by those who have suffered as a result. The facts, therefore, that you have to consider are simple ones.
It is now for the jury to retire, elect a foreman, and reach their predetermined verdict.
Members of the jury, will your foreman please stand? Please answer these questions, yes or no. Have you decided upon the answers to the agreed questions which you have before you?
Yes.
Were the words complained of in the defendant's letter and subsequent interview likely to bring the plaintiff into hatred, ridicule, or contempt?
Yes.
Were the statements true or believed without malice to be true by the defendants?
Yes.
What sum of damages do you award to the plaintiff's cosmic planning consultants?
1p.
You can join us again when our cameras return to bring you another case in the Crown Court.